listeners. We are on tonight, of course, with this program, Ministry of National Security and Legal Affairs. And tonight we have a very important person in the house, a very special guest here tonight. Thank you to your listeners at DBS Radio and Carrier FM.
Playing your games, you get your tail cut. And after that, it's ifs and buts. If I was bigger, if I was stronger, if my hands was a little longer. And all the time, you're ifing and you're butting. If and buts doesn't mean a thing. If and buts are words that you use when you want to make excuse, like, I could have this, I could have that, I should have this, I should have that. Well, if you could have,
I could have that,
you should have,
I should have that.
and if you could have,
I could have that,
you would have.
I would have that.
If you could have this, and you could have that, you would have this, and you would have that, and all the could and the shoulda, everything would have been like they would have. You could have what?
I could have that,
You could have what?
I could have that,
You could have what?
I could have that.
You could have what?
And certainly if you coulda, and if you shoulda, you coulda. That's definitely showed. And tonight we have with us a very important person, the former Attorney General of Dominica, legal consultant, and one of the most, highly regarded and recognized legal draft person in the Caribbean, having worked in so many different countries, of course, including during Cricket World Cup 2007 and beyond for CARICOM. And of course, he's no stranger to DBS Radio. He did, of course, in fact, blessed us with his presence on our very first program hosted by the Ministry of National Security and Legal Affairs. And tonight we have before us, of course, not only the listeners of DBS Radio, but also the listeners of Carrier FM. Thank you very much to all the wonderful listeners and the management and staff of DBS Radio, and likewise the manager and staff of DBS Radio, the operational manager, Miss Ito, and of course Mr. Steve Vidal, who never sleeps. We have some very important matters here to discuss here tonight, and as we continue in the ministry to try to educate members of the public. And we will be looking from a broad perspective and also clarifying and qualifying certain aspects of the discussion here tonight insofar as it relates to one's freedom of expression and movement and one's freedom of right of freedom to assembly and to associate. And we want to also look at the regional security system, the treaty in itself that gives effect to the RSS. And no better person, in my opinion, to explain the fundamentals of those topics that I just made reference to than Mr. Laronde, as I said, a draft person, and the draft people are the ones who draft the laws, and they're the ones who actually work on the intention, on what one of my professors would like to say, the pith and substance, of course, of the pieces of legislation. And so I think he's well equipped. Good evening, Mr. Laronde. I'm going to allow you to do most of the speaking here tonight, and we'll look at some of the issues that I just made reference to. And let us start firstly with you introducing yourself to the wonderful people of Dominica.
I'm Anthony Laronde. I've worked in the government of Dominica in various aspects in the legal department. As a former Attorney General, I run a CARICOM project for 9 years, and essentially what we're doing, we're making sure that the laws of all member states, except Haiti and Suriname, were in compliance with the single market and economy. I've worked in Anguilla and worked for government of St. Kitts, etc. But that's not what I'm here to talk about, not about myself. I am here, and the role I see I have is to explain certain aspects of the law which a lot of people are talking about. There's a lot of misinformation. There's a lot of, sometimes I'm not sure if it's done on purpose or if it's done through ignorance. But I just want to try to educate, try to bring people to see things from the true perspective. And I'm talking strictly in terms of law. So there's a lot of talk, and someone told me, a very intelligent young lady who goes to the college, we were in discussion, and she told me that if you cannot express yourself and say whatever you want, she does not believe it's freedom of expression. Well, most of us will know that if you write something about someone that's not true and it causes the person anxiety or otherwise, that's a problem. If you say something, that's a problem. That's why you have laws of defamation and slander, for example. And the same thing can be said in terms of the right to associate, the right to assembly. But I will refrain from just talking off my head, because I want to make sure whatever I say, no one can misinterpret. And whatever I say, I want it to be backed by what the law is. So, Chapter 1 of the Constitution of Dominica addresses the protection of fundamental rights and freedoms. That's all Chapter 1 does. And in Section 10, it speaks about protection of freedom of expression. And as I said, when I'm talking constitutional laws, I can't do it out of my head. It's not just something you say. So I'll read for you the various sections. Section 10 says, except with his own consent, a person shall not be hindered in the enjoyment of his freedom of expression, including freedom to hold opinions without interference, freedom to receive ideas and information without interference, freedom to communicate ideas and information without interference, whether the communication be to the public generally or to any person or class of persons, and freedom from interference with his correspondence. That's what the law says. That's what the Constitution says. However, we need to hear what subsection 2 says. And it's very clear. Subsection 2 says, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention with this section, to the extent that the law in question makes provision, and it tells us what the provisions can be. So yes, you have the right of expression, but the Constitution tells you, in spite of those rights that you have and you can enjoy, nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention with the section that gives you those rights, to the extent that the law in question makes provision, A, that is reasonably required in the interest of defense, public safety, public order, public morality, or public health. So any law that is reasonably required in the interest of defense, public safety, public order, public morality, or public health is not in contravention of the Constitution.
Can you just go over that for me again? And we are talking about, we are specifically referencing Section 10 that deals with the protection of freedom of expression. And I would like you to just to repeat that for emphasis. Because the reason why, and I want this show to be your show here tonight, there is the misconstrued view that if a law came into effect before the attainment of independence and before our constitution came into effect, basically, I'm not sure, I am all kind of different renditions, that the law is somehow not consistent with the Constitution. I want you to just maybe want to qualify that for us as you explain.
Okay, I'll answer that by saying anyone who is of the view that any law is in contravention of the Constitution has the option to move the court. You know, you just don't stand on the side of the road or write on a newspaper and says this is old law or the law has passed long ago. That is infantile. That is stupidness. With respect. If you think that the law is in contravention of the Constitution, you get your lawyer goes to court, and if you're correct, the law will be struck down. Simple as that.
Yeah. So, you're making a point. And in terms of subsection 2, and I'm going to allow you just to continue to give some expansion to that.
Okay, so we're saying that nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention with this section to the extent that the law in question makes provision that is reasonably required in the interest of defense, public safety, public order, public morality, or public health, except so far as that provision, or as the case may be, the thing done under the authority thereof is shown not to be reasonably justifiable in a democratic society. Now, you don't just say it is reasonably, it's not justifiable, reasonably justifiable in a democratic society. You go to the courts, and the courts will look at the law, and the courts will deem it to be reasonably justifiable or not reasonably justifiable and strike it out. This is why you have courts. This is why you have the rule of law. We cannot just determine things on our own. If we do that, we'll fall into anarchy.
No, yes.
Therefore, the law or provision thereof can be held as constitutional or deemed to be unconstitutional because it fails the test of reasonableness. And it can be so done by a court of competent jurisdiction. Or the thing done under the law or provision thereof may be held to be unconstitutional because it is not reasonable, justifiable in a democratic society. So yes, you have those rights. But in the interest of defense, public safety, public order, public morality, public health, government can pass laws. And the Constitution gives you the power, the authority to move the court for the court to determine whether the laws are reasonably justifiable in a democratic society. We will actually talk about such laws. But before we do that, I want us to move to section 11, which talks to the protection of freedom of assembly and association. Section 11. Except with his own consent, A person shall not be hindered in the enjoyment of his freedom of assembly and association. That is to say, his right to assemble freely and associate with other persons, and in particular, to form or belong to trade unions or other associations for the protection of his interests. Wonderful. Serious right. But the right is a right that has to be exercised within the ambit of the same constitution that gives it to you.
Thank you very much. I like where you put that there. I would like you to just repeat that latter part of your statement there, or your presentation.
Essentially, I'm saying that you have all these rights, but it has to be exercised within the ambit of the constitutional constraints. The Constitution says, yes, these are the rights, but let's listen to what the Constitution says about those rights. The right to freedom of assembly and association. It says nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention with this section, to the extent that the law in question makes provision that is reasonably required in the interest of defense, public safety, public order, public morality, or public health. Or that is reasonably required for the purpose of protecting the rights and freedoms of other persons. So just as in Section 10, freedom of expression, the Constitution is saying also for freedom of assembly and association, laws that are reasonably required in the interest of defense, public safety, public order, public morality, or public health, or that are reasonably required for the purpose of protecting the rights and freedoms of other persons. These laws would be held and will be held constitutional, except so far as that provision, or as the case may be, the thing done under the authority thereof is shown not to be reasonably justifiable in a democratic society. So again, there are constraints in that the law has to be reasonably justifiable in a democratic society, or what is done under the law. This is why you have the courts, and you go to the courts, and the courts will say, yes, that law is reasonably required, or no, that law is not reasonably required. Or the action is proper, or the action is improper because it has gone over the limit. It has crossed the red line. So I want to reiterate that the Constitution under Chapter 1 gives you certain fundamental rights and freedoms. But these rights can be constrained. These rights can be impinged upon in the interest of defense, public safety, public order, public morality, or public health.
And maybe, Mr. Laronde, just to, by way of qualifying your agreement in terms of the limitations and restrictions that may be imposed in the interest of those issues that you just referenced, public safety, public order, public morality, or public health, you may want to reference some of the laws that are consistent with subsection 2 of section 11. And maybe some examples you may want to talk about this popular discourse that we have been having, the Public Order Act, the Riot Act, etc. And maybe you may want to even reference COVID-19, etc. to qualify, if you understand what I'm trying to say.
Yeah, I'll be doing that.
Okay, at a time on your sequence. That's
yeah,
okay.
but I just want to talk to the Director of Public Prosecutions.
Yes.
You see, there seems to be a perception that the instituting criminal legal proceedings are done by an authority that's not the proper authority, or by persons who that is not vested in. So I just want to talk to Section 72 of the Constitution of Dominica.
Very important.
It says there shall be a director of public prosecutions whose office shall be a public office. For 6 months, a director of public prosecution in Dominica. And for quite, well, I can't put it in terms, I didn't check how long, but on many occasions, when I acted Attorney General in Anguilla, I was essentially director of public prosecutions. Because they're not independent, they do not have a director of public prosecutions, so the Attorney General carries both hats. And I must say that no one interfered, attempted to interfere, or could interfere with the office of the Director of Public Prosecutions. The Constitution says, and it's the same thing in the other member states of CARICOM, there shall be a Director of Public Prosecutions whose office shall be a public office. The Director of Public Prosecution shall have power in any case in which he considers it desirable so to do, to institute and undertake criminal proceedings against any person before any court of law other than court martial in respect of any offense alleged to have been committed by that person. The Director of Public Prosecution shall have power in any case in which he considers it desirable so to do, to take over and continue any such criminal proceedings that have been instituted or undertaken by any other person or authority. The Director of Public Prosecution has the power to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. The powers conferred on the Director of Public Prosecutions under paragraph B and C shall be vested in him to the exclusion of any other person or authority. Essentially, what this is telling us is that the Director of Public Prosecutions is absolutely and totally independent of every power and authority. No one can tell the Director of Public Prosecutions what to do, except in a limited case, that's exception C, where the Attorney General may give general or special directions. So it might be in the interest of public order, for example. It might be in the interest of public safety, where the Attorney General, and acting in his judicial capacity, can speak to the DPP and says, in that particular matter, this is what I think we should go. But the DPP is absolutely and totally independent of the executive branch of government. Now we've spoken about the Director of Public Prosecution. I want to shift and speak to the Public Order Act. I was horrified when I read a newspaper article. The writer was speaking to the Public Order Act and saying it was an old law. Well, actually, it is a law that was passed on the 14th of May 1954.
Yep.
You see, but there's nothing like an old law. There's either a law that's on the books, or a law that is repealed, or a law that is spent. A repeal law, everybody knows what it is. You want the Parliament repealed it, they changed it, or they got rid of it,
Replaced
they
it.
amended it. Or if it is spent, for example, you can have a specific law that will go for X period of time.
Mm-hmm.
For example, when we had the Cricket World Cup,
Mm-hmm.
my department, we drafted the legislation for the whole of CARICOM to regulate immigration and stuff like that. And this legislation would have been spent by X period of time because it was specific to what was happening then. Well, that old law, according to the one who can, that whole article was just misleading the public.
Mm-hmm.
And I'm talking strict law. That law was amended
4 times.
by Act of number 18 of 1973. Act number 33 of 1973. And that's not the only 2 times. But we're not talking about amendment of laws. And you will know, the public probably does not know, but one of the best legal just people in maybe the world, in the Commonwealth, would have been Cozy Harris.
Mm-hmm.
And he did the first amendment, the first revision of our laws. After that, his nephew, one of the best, the Commonwealth, Ray Harris.
Ray, oh my God, that's a professor.
That's right. He did the last revision.
Yeah. Ray Harris.
Now, when you do a revision, particularly the first one that was done with Cozy Harris and Diobag Wauti, unconstitutional laws do not remain. It was a thorough revision. The last revision was done in 1960 or something like that. So you have a Public Order Act.
It was done in the 90s, in the last one.
Well, in the 90s, yeah, but I'm saying, but prior to that, it was 60.
Yes. Mm-hmm.
The Public Order Act is an act to make further provision for the preservation of public order on the occasion of public processions and meetings in public places. Chapter 15:01, Laws of Dominica. I'll read section 3. It shall be unlawful for any public procession to take place unless a permit has been issued in respect thereof in accordance with this act. That's the Laws of Dominica. I'm not reading something I wrote. I'm reading from the laws, from the revised laws.
Or newspaper.
It goes on in section 4. If any person desires to organize any public prosecution, he shall, at least 3 days before the intended public prosecution, make application for a permit to the commissioner. Every application made in accordance with subsection 1 shall contain particulars of the point of departure, route, and point of termination of the public procession to which the application relates, and the hours between which the procession will take place. The commissioner may in any case in writing grant the application. In cases where the commissioner considers that the application should be refused, he shall forthwith refer the application to the minister with his recommendation thereon, and he shall refuse or grant the application in accordance with the directions of the minister. In cases where any application is granted in accordance with the directions of the minister, the commissioner shall issue to the applicant the required permit for the desired public prosecution, specifying therein the route to be followed and the times within which it shall take place, as directed by the minister. Any person who takes part in or organizes any public procession without the written permission of the commissioner to do so, or who aids, abets, counsels, or procures any person to take part in any public prosecution in respect of which no written permission as required under this section has been obtained from the commissioner, is guilty of an offense. As I said, that law was passed in 1954, but Section 5, which I just read, was amended by Act number 33 of 1976.
We also had amendments in 1990, yeah?
Yeah, but they were not really substantial. But you did.
You did, yeah.
Now, or to prohibit public meetings. The minister may by order prohibit during such periods as he may specify in the order the holding of any public meeting if at any time it appears to the minister that such action is necessary. The order may extend to the whole state or to any specified part or parts thereof and may at any time be revoked.
We may want to read the offense section 8, if you don't mind, because we may want to speak to that a bit, because some people have the view that you don't need permission to have a public meeting, but offense is created under section 8, which gives the police the authority to regulate. So I'm not sure if you want to reference that, if it's actually going to actually strengthen.
Well, I will, because I am here to educate and to say what the law is. Section 8, any person who at any public meeting or in any public procession uses threatening, abusive, or insulting words or behavior if intent to provoke a breach of the peace, or whereby a breach of the peace is likely to be occasioned, is guilty of an offense. Any person who at a public meeting or in any public procession wears or carries any shirt, dress, or garment, or any banner, flag, or emblem bearing threatening, abusive, insulting, or obscene words or slogans with intent to offend public morality or to provoke a breach of the peace, or whereby a breach of the peace is likely, in the opinion of the commissioner, to be occasioned, is guilty of an offense. And that section 8, was amended by Act number 33 of 1976. And incidentally, the same Public Order Act in section 9 tells us any person who at a lawful public meeting acts in a disorderly manner for the purpose of preventing the transaction of the business for which the meeting was called together is guilty of an offense. Any person who incites others to commit an offense under this section is guilty of a like offense. Any person guilty of an offense against this act is liable in summary conviction to a fine of $10,000 or to imprisonment for 6 months, amended in 1976. So it is very clear that in 1954, long before independence, the government of the day felt it necessary to have a Public Order Act. And it is very clear that in 1976, the government of the day felt it necessary to expand on it. But what's interesting is that it also endeavors to ensure that people can have public meetings without disturbance or otherwise. However, there is in place a system whereby you have to apply for permission, and you have to, when you get the permission, you can go ahead. That it can go as far as the minister. But what the law doesn't tell you, and all the lawyers out there, Dominica probably have 80 laws. You probably have a lawyer for every 1,000 people. Are you talking about 1,000 people? We have children and old people. So for 500 people, a lawyer each. So we have a lot of lawyers out there who can agree with me that you can go to the court and ask the court to strike down the Public Order Act if you believe it's unconstitutional. That is what you do in a democratic society. You don't just shout or no, you go to the court and you say to the court, this law is unconstitutional because it is not reasonably required in the interest of defense, public safety, or public order. So anybody out there, any group out there, any person, you go to the court with your batch of lawyers, and then the court, if you're correct, will say we do not need that. What we need is anybody can have a meeting. Think of it well. I get up tomorrow and I get 100 people to follow me and have a meeting at Constitutional Hill. And because I think I'm smart and I lawyer and I have support, I can stop there and people can't bring their children to school. People cannot move because I have a meeting, because freedom of expression and assembly, and we're assembling and we have no meeting. You do not have to be a rocket scientist to realize that that is just nonsensical. So that's why you have a law that says you have to apply.
And it's interesting that you're making reference to that, because most of the Caribbean countries, as you rightly said, Mr. Laronde, have similar laws, but similar constitutions. But the Public Order Act are more far-reaching and stringent than ours. Even during the discussion a couple of weeks ago, they made reference to England and how the Riot Act was repealed, what they were not saying, and that element of the Riot Act was incorporated in the 1986 Public Order Act. And in 2023, the Public Order Act was further expanded to give the police more exclusive powers. You cannot disrupt, as rightly said, or prevent the operation of the airport or the railway, or maintenance work on the road, or construction. All those things are incorporated in 2023, and they want to use England, and etc. So you're right. So the notion that you can just decide you have an issue with the East Lubbock Bridge, so to speak, that at 8 o'clock on Monday morning, you decide to have a meeting or a demonstration for 3 lanes instead of 2 lanes, and you need not to get permission to do that, is okay. As you rightly said, it's not possible to have civility in society with that kind of mentality, Mr. Laronde.
Yeah, it just cannot work that way. You must have a certain amount of order. So this is why you apply to the police. And if the police just flippantly refuses to give it to you, then you go to the court for judicial review. If the minister, you go to the court for judicial review. But the police must be able to say, we cannot let you have it at this time, or we cannot let you have it in that location, in the interest of defense, public order, public safety.
Yes. I'm already getting some messages there. People are listening to the program. It's so very sad, but Carrier from also have joined in. We're having some technical issues. Working on to that with the most experienced engineer in radio, but we eventually got there. It would have been nice to have had Carrier FM on. We were promoting it to have this program on both radio stations. But people will be able to call if they so wish. But we just want to Mr. Laronde to do some more explaining to some of the issues here tonight. So I'm not sure. Yes, you quite in a very comprehensive manner, Mr. Laronde, spoke to the Public Order Act. I'm not sure if you want to. Maybe we're not seeking to litigate anything here tonight as before the court.
Well, that's impossible.
And the Riot Act was under a lot of criticism, and using the same kind of language. It's an old act. It comes from Britain, etc., etc. And you may want to give some clarification on that, consistent with what we're talking about here tonight.
Okay, the Riot Act was passed on the 30th of December, 1897. It's still on our books. It has been amended by Act 6 of 74. You can say it's an old act, the way it's drafted and so on, but that does not make it unconstitutional. Now, it's an act relating to riots and unlawful and tumultuous assemblies. Now, just looking at what the act is for, the purpose of the act, I think one can quickly see such an act would be reasonably required in the interest of defense, public safety, and public order. But one can go to the courts and ask the court to strike out the Riot Act if you believe that it is not necessary in the interest of defense, public safety, or public order.
Well, that matter is being appealed, but of course there was a test when there was some riots outside of Macmillan gas station, and the state was actually challenged, and there was a ruling to the extent that the police acted reasonably, and reference were made to a number of pieces of legislation, not only in Dominica but as far as England. Reference was also made to the Police Act that gave the police some far-reaching authorities. To regulate meetings and processions, to remove any obstruction on any public thoroughfare. That give the police the authority to enter any area or place where people are paying for amusement, and if there's this order, once the officer is on duty, that officer can enter to put order and to arrest people who are committing crimes. So you have far-reaching authorities of the police, not only in the Public Order Act, but in several pieces of legislation that give the police the authority to regulate and to apprehend people so far as disruptive behavior is concerned, or criminal behavior is concerned in the public domain.
Yeah, and you're correct in terms of, but the Riot Act is very clear. It talks of punishment for riots. And the person who is convicted of the offense of riot is liable to imprisonment for 3 years, either in addition to or in lieu of any punishment other than imprisonment, which may be inflicted upon any such offenders by the common law. Unlawful assembly. Any person who is convicted of the offense of unlawful assembly is liable to imprisonment for 2 years, either in addition to or in lieu of any punishment other than imprisonment which may be inflicted upon any such offenders by the common law. Now, when a situation exists that appears to be a riot, there's a proclamation made in reference to the unlawful assembly. And if the people persist, the law takes its course. The Riot Act tells you the form of the proclamation. His Excellency the President charges and commands all persons being assembled immediately to disperse themselves and peaceably to depart to their homes or to their lawful business upon the pains contained in the Riot Act by command of the President. And then the law takes its course. Like I said, can you imagine a country without laws or particular law that would contain riots? I don't think you could have a country with that. You must have a Riot Act. You see, we have to distinguish between having a law, for example, dealing with riots, and the fact that the action taken under the Riot Act, the action has to be reasonably. The action has to be within the law. If the action is outside the ambit of the law, clearly the state would pay the consequences.
But as you said that there, I would like you, when you made reference to the reading of the proclamation, I guess you're referring to Section 5. But maybe after Section 5, and you have a situation where the proclamation has been read, people have been asked to disperse. The police, after reading the proclamation, can take action to disperse the crowd. That's why you had the discharging of, you can discharge tear gas, rubber bullet, or whatever the circumstances that actually arise would necessitate the action of the police by way of response. But I think it's important for reference to me to Section 6. And the police has read the proclamation and they have taken certain action to disperse the crowd. And people are still agitating, they're still there, throwing rocks, etc., etc. Then even if an hour passes by and the police still trying to disperse and asking to disperse, taking necessary action, what is the exposure by way of liability? People who remain beyond the expiration of this hour, and if the police were to act, and certain actions were to be taken by the police, and in trying to apprehend people, people get injured, or what is the liability of the police? Because it's important for people to understand when the police act, following the law under Section 6, and the police cannot be held liable. Once the police follows certain steps, I would like you to go through Section 6 and read it out to the public, if you don't mind, Mr. Laronde.
Yeah, but then to do that, I'll read part of 5.
Yes, sir.
The proclamation is in the following words, or words of like effect. His Excellency the President charges and commands all persons being assembled immediately to disperse themselves and peaceably to depart to their homes or to their lawful business upon the pains contained in the Riot Act by command of the President. I mean, this is extremely clear. And every magistrate and every justice of the peace or the senior police officer in the area are hereby authorized, empowered, and required on notice or knowledge of any such unlawful, riotous, or tumultuous assembly to resort to the place of the unlawful, riotous, or tumultuous assembly of persons to the number of 12 or more, and there to make or cause to be made the proclamation in the manner mentioned above. Where the persons so unlawfully, riotously, or tumultuously assembled, or 12 or more of them, after the proclamation is made in the manner mentioned above, continue together and do not disperse themselves within 1 hour, then shall be lawful for every magistrate and every justice of the peace or the senior police officer in the area, and for every police officer, constable, and other peace officer of the state where the assembly is, and for every other person as shall be commanded to assist any magistrate or justice of the peace who is hereby authorized and empowered to command all persons of age and ability to assist him therein, to seize and apprehend, and all persons so commanded are hereby required to seize and apprehend the persons so unlawfully, riotously, and tumultuously continuing together after the proclamation is made, and forthwith to carry the persons so apprehended before magistrate or before one or more justice or justices of the peace, in order to their being proceeded against for such offenses according to law. And if the persons so unlawfully, riotously, and tumultuously assembled, or any of them shall happen to be killed, maimed, or hurt in the dispersing, seizing, or apprehending, or endeavoring to disperse, seize, or apprehend them, by reason of their resisting the person or persons, so dispersing, seizing, or apprehending, or endeavoring to disperse, seize, or apprehend them, then every such magistrate, justice of the peace, police officer, constable, or other peace officer, and all persons aiding or assisting them, or any of them shall be free, discharged, and indemnified, as well against the state as against all other persons of, for, or concerning the killing, maiming, or hurting, of any such person, so unlawfully, riotously, and tumultuously assembled as shall happen to be so killed, maimed, or hurt as mentioned above.
Now, and I think that's a lot of words there. It just tells you how serious the offense of riot is. And just so if you just because they were making a lot of reference to England and Wales and repealing of the Riot Act, but that Riot Act basically, as I said earlier on, was inserted in the Public Order Act, and they have removed the reading of the proclamation of the Riot Act, of the Public Order Act in England and Wales, and expanded it in 2023 with more sweeping arrest powers to the police, because they regard riot as a very serious offense, especially around certain public infrastructure. And I think so that's what we're talking about, and it's important for people to understand their rights, but also understand the degree of exposure that they are subjecting themselves to. And I believe discussions like that need to carry on, and to ensure that our populace, yes, you have a right to express yourself, and of course there are certain prescriptions in a democratic and civilized society that we have to be mindful of.
Yeah, I just want to make a statement. You see, it's not a question of what the law ought to be. Fellow Dominicans, we should not be misled to act because we are told what the law ought to be. One has to operate within the constraints of the law. As I've said before, and I'll repeat, any law that is unconstitutional will be struck down by the courts. But any law that is on the statute books, we have to comply with the law, in spite of the fact that we don't agree with the provisions of the law. In spite of the fact that it is a very old law, whatever that means.
Right.
In spite of the fact that it does not exist in other countries. Once the law is not repealed, we have to operate within the law that's on the statute books. The last section I read is very clear. You have a riot, the proclamation is read, and the police can apprehend people and do their work if within an hour you do not disperse. And they can call on citizens. They can call on able-bodied persons to help them. And the law shields them from liability. You see, but we need not go that far if we understand and appreciate that we have to operate within the confines of the law. There's nothing like bad law, unless the law has been struck down by the courts.
Yeah, having said that, and I think we need to amplify that a bit, that riot is an offense in every civilized society. And the laws in Dominica reference to riot is mild as to what obtains in other countries. The Public Order Act is mild to that obtained in other countries, even close to us, close neighbors, etc. And so what we and then it becomes necessary, as you have seen in other countries, the expansion of the Public Order Act, as you have seen in England and Britain, England and Wales, the expansion of the Public Order Act to include riot, to include that you cannot prevent the operation of the railway. You cannot prevent the operation of the airport. You cannot prevent the maintenance of a public road or the construction of a main road. All those things are contained in the Public Order Act in the same England that they're making reference to, as recent as 2023. That you cannot say certain things in protest. You can't watch people in particular ways, and the police can search people without suspicion in a protest. All these things are obtained, and so it's important for us to understand that yes, and we have to give Mr. Laronde tremendous credit to the drafters of those legislations. I mean, they were so futuristic. You understand? To the extent to which, yes, as they said about it was repealed in England, it was repealed in England, but retained and expanded in the Public Order Act to the extent to which they removed the proclamation in the for a riot in the riot offence under the Public Order Act in England. I'm referencing that because I heard so much reference was being made to the fact that it's an old law, it came from England and England repealed theirs, but they're not talking about what transpired thereafter. And I think in the discussion, we have to educate the public in all forms, and not to hide sort of things away from them to suit our whatever agenda that we may have. But the program here tonight is to educate, and we, as I said, we will hoping to have had Career FM, but they also mixed up with the time, etc. to some other time. But if you may want to call, we have a few more minutes remaining.
Yeah, well, I'd like to
before
quickly,
we go.
Yeah,
okay.
I've been saying that if any of the provisions of the Constitution, protective provisions, protection of freedom, fundamental rights and freedoms, I just want to reference Section 6, which says which says if any person alleges that any of the provisions of Section 2 to 15 inclusive, that is fundamental rights and freedoms provisions, has been, is likely to be contravened in relation to him, or in the case of a person who has been detained, if any person alleges such a contravention in relation to the detained person, then without prejudice to any other action with respect to the same matter that is lawfully available, that person or that other person may apply to the High Court for redress. In other words, I keep saying that you can go to the courts to deem it unconstitutional or whatever, but anytime you protect your fundamental rights and freedoms are under attack, you can go to the High Court for redress. Now, just before we go, I need to talk about Section 41 of the Constitution.
The right to make laws.
It's a very important section, which says, subject to the provisions of this Constitution, Parliament may make laws for the peace, order, and good government of Dominica. Every Constitution has that. Parliament, subject to the provisions of this Constitution, Parliament may make laws for the peace, order, and good government of Dominica. Now, we said we'd be talking about the RSS Treaty and so on. We have no time tonight, but just before we go, I want to speak about something that's extremely important as we talk about what has happened. I do not know. I don't know the facts. I'm not part of that discourse. I'm talking law. And I'm talking law because I would like my fellow Dominicans to act within the law, to exercise their rights and freedoms within the law, and I also like to make my fellow Dominicans, as much as I can, understand, to borrow Honorable Minister's term, the exposure. And this is why I want to speak about the Treason Act.
Right.
The Treason Act was passed on the 22nd day of March, 1984. It's a short act, but I'll read it because a lot of things are happening and a lot of people, I believe if you want to be a farmer, learn about farming. You can't be a mechanic and just go on land and say you're a farmer. So you have to educate yourself, educate your people, if you want to do whatever you choose to do properly. So I think it's essential that we speak to the Treason Act. A person owing allegiance to the Commonwealth of Dominica, who, whether in Dominica or elsewhere, A, forms an intention to levy war against the state or to overthrow the government or the Constitution of Dominica by force of arms, and manifests such intention by any overt act, or B, adheres to the enemies of the state by giving them aid or comfort, is guilty of treason and liable on conviction to death by hanging. Now, any person who forms an intention to effect any of the following purposes, that is to say, very important, please listen, levy war within the Commonwealth of Dominica in order to, by force of arms, to depose from his office the President, to depose from his office the President or any member of the Cabinet or any member of the Cabinet.
Mr. Laronde, 1 second while. Good evening. You're live. Good night.
Good night, good night, good night.
How are you doing?
I'm doing fine, thank you, sir.
Okay. Thank you for calling. You have a question or you want to make a contribution?
Yes, I would like to make a comment.
Yes.
In respect of the Riot Act, particularly Section 5, an excerpt of which makes reference to His Excellency the President. Now, I've heard several debates on radio stations as to when the Riot Act was first enacted in 1897. But if you were to do a research on our sovereignty, in 1897, we did not have a president as our head of state. I believe it was maybe one of the kings, King George the Third. So if presently in the Riot Act, we have the expression, His Excellency the President, isn't that expression indicative of our independence, which took effect on the 3rd of November 1978? I just wanted the gentleman on the show to give some highlight on that. I tuned in just about 20 minutes ago when I was driving from the city to home. As I arrived home, I decided to just call.
Thank you very much, sir, and God bless you. Thank you.
Yeah, the response to that is, as I said earlier, our laws, a thorough revision was done by one of the best law revisioners in the Commonwealth in 1990. So when that revision would have been done, these changes would have been made to bring it in sync with the Constitution. So all our laws, these changes would be made. President, Commissioner of Police instead of Chief of Police, all these changes would be made. But like I said earlier, any law that would have been unconstitutional would have been pulled out of the books. But I also said that one is free to go to the courts. But it is very important that I go back and I read Section 3 of the Treason Act. I don't want to leave here before that's done.
Very important. Let's go.
Any person who forms an intention to effect any of the following purposes, that is to say, levy war within the Commonwealth of Dominica, in order by force of arms to depose from his office the President or any member of the Cabinet or any judge of the Supreme Court, or in order by force of arms or constraint to compel the government of the Commonwealth of Dominica to change its measures or counsels in order to put any force or constraint upon or in order to intimidate or overawe Parliament. B. Induce any alien with force of arms to invade the Commonwealth of Dominica and manifest such intention by an overt act is liable on conviction to imprisonment for life. I just felt I need to tell
Yes.
my people that, my
Yes.
countrymen.
Yes, I believe.
You cannot, should not, it has happened before in Dominica. The Treason Act was passed on the 22nd March 1984, and it is telling you that anyone who decides that they'll stop Parliament, that they'll break the mace, that they'll bring the people in Parliament into fear, that they'll stop the proceedings, commits the crime of treason and is liable on conviction to imprisonment for life, fellow Dominicans. That's what I'd like to share.
The fact
I did not write the law. The law was passed 22nd March 1984. Has made the Parliament sacrosanct. No one can go to the Parliament and stop the proceedings and interfere with Parliament. Liable to imprisonment for life.
Okay. Good evening. Good evening, we miss a call. Hello. Good evening. Hi. Good night.
Hello, good night.
Good night. You're live.
Yeah, Mr. Blackman, I really want to compliment Mr. Laronde for really you having a great program. I was saying to myself with my friends, I would like him to go on another radio station to really teach the other people, how the law of Dominica, because sometimes when you hear other radio stations, you hear different things, but the fact that that's his field, and then he really explaining to the people. I hope a lot of people listening to that program, and I don't know if I saw Curtis was watching. I would like him to replay that program again one of them days, to let people know. Even when you come on the program, Mr. Blackmore, you're trying to explain to other people on the other radio station, and they're not taking you positive like what I'm laying tonight. So no wonder they say the wise people come from the east. Mr. Laron, it's a good thing you from my area.
Yes.
So that's why they always say the wise people come from the east. So I really appreciate your program, and I want you to take it further. If we have to do something to pay the other radio station boy to go on the radio station to let them know what you say in there, we don't mind do it, man. But a great program, no wonder they say the white people come from the east. Great job, Mr. Tony, Mr. Laron.
Thank you.
Good evening. And so,
Yes.
good night. Yes, so excellent intervention there from our colleague. Yes, Mr. Laron. So we plan this program here tonight, and with a particular intent, and with a view to educating the public, but at the same time trying to get within the psyche the degree of exposure that they put in themselves, and that as you made reference to the whole issue of treason. You and I, we have been talking about that. We'll talk about it just now. It's something that happened. I don't want to talk about it because the matter has been appealed. because I heard the former Prime Minister asking of the minister to make public the investigation of the same matter, which is of course a live matter before the court. And I said to him in a private discussion, it wouldn't be in his best interest for that to be done, because we have to be careful the activities we get ourselves involved in, especially around certain infrastructure, public infrastructure, as you rightly said. And it's important for us to try to litigate these issues there for people to understand what we're talking about. I'm not sure if anybody is trying to call it tonight. Good evening. No, we missed the call. So, Mr. Laronde, a wonderful program. We wanted to talk about RSS
Next time.
next time, and we may have time for one more call if anybody want to call again. And as you close, Mr. Laronde, here tonight.
Good evening, listeners. I'm very grateful that you gave me your ear. Have a wonderful Easter.
Yeah, so I see you don't want to spend 5 more minutes, so I know it's Lenten season, but we'll be back again. We're hoping to have had Carrier FM, and of course we can also have Q, all 4 radio stations, and we shall be back again on the last Thursday of this month. What's to this date? And we'll be back again, and we're going to bring you back, and we'll speak to other issues and that we could have spoken about tonight, because your right to life is protected also under the Constitution, but insofar as some other laws are concerned, and so all that we may want to speak to also, and the authority of the police to detain people under the same Constitution for a period of 3 days before taking the person before the court or releasing the person. So there are a number of issues that we want to actually bring further light to, as we seek to continue that endeavor to reach out to the public and to provide information to them on very important subject matters. So it was nice having you, Mr. Laronde. I mean, you came well dressed. I thought that you looked like a police officer tonight. Yeah, well shaven, etc. And you're shit in your pants and stuff like that. And I want to commend you for. I know you should have been in church tonight, but we shall be back and to speak more to that subject matter on a subsequent program on DBS Radio, and we will join free radio station. We'll invite all of them, Mr. You agree to that?
Sure.
No problem. Okay, fine. One love. So, have a nice night, sir.
Okay.
God bless you, man.
Bye-bye.
Okay, one love.
Very much. Ladies and gentlemen, they gave me the 3 most